morning, everyone. Once again, I am Joy Josiah, the Secretary of the Caretakers Committee, Ahmadu Bello University, Zaria, and I'll be your moderator for today. The first on our agenda this morning is an opening remark by Joseph Omoha, the Chairman of the Caretaker Committee of Ahmadu Bello University, Zaria. Let's welcome him. Joseph, you have the floor.
Good morning, everyone. My name is Omoha Joseph, the founder of the ADR Society, Ahmadu Bello University, Zaria, and the head of the Caretaker Committee of the Society. This is to welcome you all to this introductory webinar themed Beyond Litigation, organized by the ADR Society, Ahmadu Bello University, Zaria, in collaboration with the Settlement House ADR Training Institute, SHATI. The ADR Society, Ahmadu Bello University, Zaria, got officially established less than 6 months ago, and we'll be celebrating the opening of the society's and inauguration in a few weeks' time. So this webinar is a kind of pre-launching event to get students and other interested persons acquainted with the fundamentals of ADR. So without much further ado, we would be commencing the webinar in earnest now while others joining. Thank you.
Thank you very much, Joseph. So as earlier said by Joseph, the theme of this webinar is Beyond Litigation, an introductory webinar on ADR. So I implore everyone to sit, relax with a book and a pen as we glean from the wealth of knowledge our speakers are going to be sharing with us this morning. We have 3 speakers, the first and the second speaker and a discussant. And so the next agenda now is to read the profile of the first speaker in person of Mr. Nanchang Nangwang. Mr. Nanchang Nangwang is a lawyer and the principal partner of the law firm N. Nanchang and Co., a law firm based in Kaduna, Nigeria. He's a certified teacher, trainer, and facilitator. He's a faculty member and the Institution for the Training, Certification, and Practice of Alternative Disputes Resolution. He's a faculty member of Nigerian Institute of Chartered Arbitrators. He's also a certified dispute resolution specialist, an international mediation advocate, an ADR practitioner, a restorative justice practitioner, and a certified conflict manager. And also he's a restorative justice practitioner and a certified emotional intelligence specialist. He has keen interest in the application of ADR in the resolution of medical and negligence disputes, workplace disputes, commercial medium, faith-based disputes, land disputes, family disputes, among others. As a dispute resolution specialist, he has handled several disputes which were amicably settled out of court. He's ever willing and ready to volunteer for and contribute to the development and practice of ADR. Join me as we welcome Mr. Nanchang Nangwang. Thank you very much, sir. You're welcome, sir. Okay, we'll be moving to reading the profile of our second speaker this morning. Just give me a minute while I sort that out. Our second speaker for this morning is Dr. Odoh Ben. Mr. Odoh Ben is a United Nations Peace Ambassador and the Director, Legal Clinic, Faculty of Law, Nigeria Police Academy, Kano. He holds various law degrees and was trained at the Ebonyi State University, Abakaliki, the Ahmadu Bello University, Zaria, the Nigerian Law School, Kano campus, the University of Johannesburg, South Africa, and the Nnamdi Azikiwe University, Oka. A barrister and solicitor of the Supreme Court of Nigeria, member, Institute of Chartered Mediators and Conciliators, ICMC Nigeria, member, Chartered Institute of Arbitrators, UK, and fellow, Institute of Corporate Administration of Nigeria. He is the legal advisor of Assemblies of God Church, Nigeria, Kogi District, the lead consultant to Negotiation Powerhouse, and a neutral to Kano Multi-Door Courthouse and Settlement House, Ghana. He's published in journals and books. Join me as we welcome Dr. Odoh Ben. Okay, he's not here in our midst right now because of circumstances beyond control, but he's going to join us while we are still in the meeting. The third speaker, who is a discussant in this meeting today, is Mr. Samuel Orobosha Osarenren. He's a certified peace and security consultant, chartered human resource consultant, lead facilitator of the Pezit, Curry and Associates Consults, dispute resolution officer, Edo State Multi-Door Court House. He's also a fellow, Institute of Chartered Mediators and Conciliators, a member of the Nigeria Institute of Chartered Arbitrators, a fellow of the Chartered Institute of Human Resource Management, a member of the Society for Peace Studies and Practice, and also a member of the Association of Multi-Door Courthouse Practitioners. These are our speakers for today. Join me as we welcome them this morning. Thank you very much. We welcome our first speaker for today's webinar, Mr. Nanchang. Please, you can have the mic, sir.
Thank you very much. Thank you. Thank you. I must appreciate the, I must first start by appreciating the management of the ADR Society, ABU Zaria, for making this possible. I really appreciate. Also want to thank management for giving me this opportunity to speak to and share my thoughts on what is a passion for me. This is something I do not take lightly. I want to also use this opportunity to appreciate the opportunity of sharing this platform with some distinguished ADR practitioners. I'm actually opportune, Mr. Odoh Ben and Mr. Samuel. I'm actually delighted to share this platform with you all. Thank you very much. So without waste of time, I am the Executive Director of Settlement House ADR Training Institute, and I will want to go straight to our business for today. Before we proceed, Settlement House is an ADR training institute that trains and certifies ADR practitioners both within and outside Nigeria. We organize also continuous professional development trainings for our members and also members of the ADR Society or community, both within and outside Nigeria. We do that under the platform of the settlement hour. We call it the settlement hour. We pick very, very important key issues in ADR, and then we get speakers who are very vast in that area to discuss it. And for now, we give access to all our members. We give them access, and members of the ADR community, we give them access to these materials and the trainings for free under our continuous professional development. And we are very eager and willing to see how we can contribute to the development of more ADR practitioners, both within and outside Nigeria. So that said and done, my profile has been read, and I will go straight to the business of the day. So we are looking at the topic beyond litigation, an introductory webinar on ultimate dispute resolution. So just a minute. Okay. Okay. So can you confirm if you can all see my screen?
Yes, sir, we can.
Yes, we can.
Okay, thank you. That's good. So, you are all co-hosts, the ADR Society, and then so you can mute participants and perform some administrative function where necessary. So, without waste of time, I would like to go into definitions of some concepts. You know, we are looking at beyond litigation, you know. So, you know, in every society, one thing that we need to understand is that every society is full of situations that warrant conflicts or disputes. And these are things that are beyond any contention. These are things that happen in our society. So I will want to begin by helping us understand that we have, this is our learning outcome for today. This webinar is targeted at trying to help get the participants understand. Okay, our learning objectives for today is to get our participants understand the emergence, the nature of ADR, and then some of the skills and mechanics of ADR. You know, some of the skills you may need to become an effective ADR practitioner. And then we'll look at some of the ADR mechanisms that are available, and then we'll look at the relevance of ADR. All these things are going to be contained in our conversations and discussion. And our learning outcome for today is we're expecting that at the end of this webinar, participants or students should be able to explain how and why ADR came into being and its peculiar characteristics, and Participants should also be able to understand how to engage ADR as a means of peaceful resolution of disputes, and then to also understand the various platforms available for in ADR for the peaceful resolution of disputes, and more importantly, how to nurture or develop their interest to maturity when it comes to ADR. Now, definitions, if you look at some of the things that the keywords in what we're looking at, you see ADR, you see litigation, you see emergence, and you see nature, skills, and mechanics. So ADR simply, as people may want to say it's an alternative dispute resolution, and then I call it appropriate dispute resolution. It has different names, some refer to it as negotiated settlements, and all of those things. Then litigation, we know this is a formal way of, airing your grievance against any form of issue, conflict, or dispute without taking the laws into your hands. Now, emergence of ADR, definition. By definition, emergence is like coming into being, coming into light. When something comes forth, how did ADR come about, and then the nature. You are looking at some of the characteristics or some of the things that make something what it is. In these terms, what are the characteristics or the nature of ADR? And then we'll be looking at the skills. What are the things you need to have or know, the abilities you need to possess to be able to be a successful ADR practitioner. So we say that what we need to know about conflict and dispute is that they exist everywhere, be it in the church, in the mosques, in our society, in our businesses, in everything that we do. They exist everywhere. Intentionally, unintentionally, they exist. And then you look at, if conflict exists, conflicts are not things that you just leave open or just allow them the way they are. Conflict exists, and then since they exist, disputes exist. If they exist, there is need for us to find solutions to them. And that brings us to the opportunity. Since conflict exists, disputes exist, these are problems that needs to be solved. And this brings opportunity for people who are interested in helping people resolve disputes. So I used to say that, if you want your business to survive, try to engage in business that are like a necessity in the society, like water. People will always use water for building, for drinking, for a lot of things, bathing. So if you are into the business of selling water or making water available to people, you will never go out of business. So also conflicts and disputes abound in our society. So for you to be able to go into a business that help people resolve conflicts or manage their disputes or resolve their disputes, you are going to go into something very, very important and crucial. One, for the sustainability of our society, for peaceful harmony and coexistence, among several other things, because where these things are not resolved, we are really heading into trouble. So now the emergence of ADR, you look at it from the pre-colonial era, where our societies usually resolve disputes through some mechanisms they put in place. First, where a dispute occurs, the disputing parties actually try to resolve these disputes among themselves. We are talking about way back, far back before the advent of all this modern way of resolving disputes. So even the ADR we're talking about, they exist in their forms as at then. But then, people of those times where dispute occur, you see people try to resolve them themselves, resolve those disputes themselves, and where they cannot be able to resolve the dispute, they seek for the assistance of their kingsmen. And these kingsmen, you know, for the first part, that aspect has to do with negotiation. That is what we call today negotiation. It happens between the two disputing parties or their representatives. Then where they are not able to sort out the problem, they now seek for the assistance of their kingsmen. And then in these terms, we call it mediation, where, you know, a kingsman will help the parties resolve the dispute. And where, you know, the mediation fails, you know, they take a step further by referring the disputes to the headman in the neighborhood, for example, you know, where this dispute occur, whether from the part of the person who is complaining or the person who the complaint is laid against. And this is known as neutral evaluation. You want to hear the opinion of a third party who is neutral, who will be able to give a fair assessment of the situation so that you know which way to go. And then if this method fails, you know, you now refer it to the high chiefs or the kings, you know, the rulers in the environment where they make decisions which is going to be binding, which, you know, that is what we refer to as arbitration now, where the disputants submit themselves, you know, to a third party who has the power to make a decision that will bind them. Now, this method I explained, you know, actually are available as at that time, far back, and you can see them exemplified in the major tribes we see in Nigeria. You know, the Yoruba, the Igbos, and the Hausas. You know, we are not saying that the other tribes, the minority tribes, do not have their own way of, they also have these things, but we're trying to make an example with this particular one. Now, prior to colonization, this system was jettisoned with the advent of colonization and traditional legal system branded, you know, these methods of resolving dispute as repugnant to natural justice. So now, if you look properly, you also understand that the formal way of resolving dispute was introduced in Nigeria, and then when it comes to ADR, particularly for us in Nigeria, you know, and in Africa, we have the formal introduction of ADR when the Lagos Multi-Door Court House was established in 2002, you know, as a private, through a public-private partnership between the High Court of Justice of Lagos State and the Negotiation and Conflict Management Group, MCIArb, you know, which is a non-profit private organization. These two organizations come together and then they become instrumental in the establishment of the Lagos Multi-Door Court House in Nigeria and in Africa. And from there, we now see that there are different ADR organizations, multi-door court house, like the Abuja, the Edo, you know, all those other ADR multi-door court house, you know, were established. You know, so in 2007, you know, there was a statutory backing to the establishment of the multi-door court house as at 2007. So the main purpose of the establishment of this, the multi-door court house, was to serve as an avenue for the promotion of ADR in Lagos, eventually in Nigeria, in Africa at large, you know. So, and they want to, the essence is to see that people explore ADR as a way of resolving their disputes peacefully and amicably. From there, that is how we can trace the history of every other organization. I must mention that ICMC, that's Institute of Chartered Mediators and Conciliators, were very instrumental, you know, as a formal, one of the first foremost formal institutes that started the to preach the gospel of ADR as an institution. You know, the multi-door courthouse is a court-connected ADR center. Now, ICMC becomes one of the first institution, that's institute, to promote, you know, the training, the practice of ADR, especially in mediation and conciliation. Now, we have several other ADR organizations as of today, and SHATI is one of them. SHATI is Settlement House ADR Training Institute. We train and certify ADR practitioners. Now, without waste of time, we want to go straight to the nature. We have looked at the emergence, the nature. Now we're looking at the nature and the relevance of ADR. Nature and relevance of ADR. Please, can you confirm if I'm fast or it is? I hope it is okay. Am I fast?
It's okay, sir.
So
Okay.
yes, your pace is okay.
It's fine.
Okay, that's good. Now, it excites me to talk about the nature and the relevance of ADR in our society, because you see, when you look at our society today, you know, to avoid situation where people who are involved in conflict and disputes take the law into their hands, you know, we now have formal systems established for the ventilations of grievances against the states, against individuals, against anybody you feel offended with his acts or action or behavior. Now, this formal system is the court system, which is established on different level. We have the lower courts, either area courts or magistrate courts, and we have the customary court, we have the Sharia courts, we have the high courts, we have the national industrial courts, we have the court of appeal, you know, we have tribunals, and then we have the Supreme Court. All these courts are set with different jurisdictions to be able to help people activate their grievances, you know, ventilate their grievances appropriately. But you see, you know, a layman may not be able to understand what the jurisdiction of the court is. So you have situations where a Christian goes to a Sharia court to file a matter, or, you know, and things like that. So you need proper guidance. That is where the problem comes. You know, you have someone who is aggrieved, you know, without knowing which particular court to go to, he can just go to any court. So this is one of the problems with litigation, you know, the complexities in the procedures in order to activate the jurisdiction of the court. And if you file a matter without proper jurisdiction, you know, that matter does not have life in it. So you see that the disputant or the person affected has a long procedure, has a long, you know, he has a lot of things to do, either to engage the services of a lawyer, you know, the expenses involved, and then more critical, more important is the delay associated with, because of the procedures, the things that needs to be done to be able to activate the jurisdiction of the court and follow through till judgment is delivered. So, but then when you come to ADR, beyond litigation, you come to ADR. ADR avails you opportunities because of its nature. First among all those other things is that the ADR is party-driven. Party-driven in the sense that, you know, unlike the court system where you file your case and then the chief judge or the staff that is responsible for assign your matter to anybody he feels like, you know, a judge, you know, you don't have a say to it. And when you go to the court, you sit down and sometimes you are terrified. You are terrified And then, sometimes you forget about some of the things you want to say, and then you don't have a say in the process. The lawyer is the one who speaks on your behalf, and if you don't have a lawyer, you speak, and then your facts that you are presenting will be distorted because you are tense in that environment. But when you come to ADR, you discover that the parties are actually involved in the resolution of their dispute. First, in all the forms of ADR, it's either they are involved personally in negotiating a settlement, an amicable settlement for themselves in negotiation, or they are the one who will appoint a third party neutral who is going to be the one to help them in terms of mediation to facilitate their discussion towards an amicable settlement, or they will give that power to someone they trust to appoint the person on their behalf who is going to help them resolve their dispute. So when that is done, you see that the party becomes satisfied with the process because he's involved. They are the one who discuss their problem. They are the one who explain their problem. They are the one who decides the solution for their problem, from the beginning to the end. And in instances like conciliation, where maybe someone is allowed, the third party is allowed to make some suggestions, those suggestions are still subject to the approval of the parties themselves. So that is the nature. That is one thing that makes ADR very, very critical and very important, because the parties get involved. Unlike a process where after you file, you do your arguments and then judgment is delivered, you see that the party says no. It's either they bribe the judge, or something happened, the judge did not understand what I was saying, or he did not see the papers I presented and all of those things. Then you see appeals. Somebody appeals to the High Court, and then from High Court to the Court of Appeal, from the Court of Appeal to the Supreme Court. So you see dissatisfaction, but where parties are involved, you discover that the outcome of the dispute, the outcome of the discussion or the settlement becomes the ownership. It becomes the parties can identify and own the outcome of the process. And you see more in compliance. You see that parties comply with the outcome of the settlement more than that of the court. Most times, when judgment is given, you hardly see people who just decide to go and pay until execution is levied. So you see that's one critical aspect of it. Now you see options. In the course of discussion, the third party neutral, like in other forms of ADR aside from arbitration, you see the parties have varieties of options. You can start with a claim for your money, which you gave to someone, and then at the end of it, the solution for that problem may be that, oh, I have a land, which is worth that amount of money. Can you take it? So you have varieties of options, varieties of solutions. And that is what the ADR practitioner does. His training is to help you develop the ability to look at several options, explore several options in the resolution of your dispute. It can be a line dispute, at the end of it, you say, oh, I can pay you the money equivalent. Oh, I have a beautiful daughter. Can you take her and marry her? And then if that is okay, and forget about these disputes. You can have variety of options. That's what I'm trying to say. That is ADR for you. And you see, when parties resolve their disputes and they move ahead, it is difficult for you to go to the court where judgment is delivered, and then you see the person whom judgment was delivered against, stretch out his hands to shake the winner of the day and say, oh, congratulations, you actually did well. It's very, very difficult. It's really, really, really difficult. So that is why you see, we always say that it is actually better to use ADR because, parties can resolve and continue with their relationship. It will be hard for parties to resolve through litigation and still continue their relationship, no matter the kind of relationship, except where it becomes extremely, important or necessary. So that is why we said ADR protects the relationship of the parties. Now you see that unlike the court system where you just walk in, and then you listen to the conversation, listen to everything that is going on, and then during cross-examination, they may ask you questions that relates to your trade secret, and then you are bound to answer the question under oath. ADR is private and confidential. All the processes, aside from the parties themselves and the third party neutral or any other party that the disputants decide to accept or bring into the negotiation room, nobody else is allowed into the room. Nobody else. So you see, anything you discuss is private and confidential. And do you know that? Very, very important, and I'm so excited to say that the Arbitration and Mediation Act of 2022, which was just ascended to by the past president of Nigeria, clearly states that conversations that you have during your mediation or ADR session, are actually, private, confidential, and you cannot invite either the mediator or the parties or use any of the documents you use during the negotiation or the discussion in court. And no court can summon you to bring those documents or state what you have discussed during the negotiation. All of those things are protected. So you can see they are private and confidential. In the court, I can just walk in and apply for CTC, pay the fee, and then I have everything I want. So you can see. Now it saves your time. When you commence an action in court, you don't know when you are going to end. And parties and disputants and clients of these days are very, very interested in this aspect. People are tired of going to waste years in court, resources in court, and then at the end of it, the outcome of the judgment may be irrelevant for the moment. Imagine you collected money like 10 years ago, and then after like 10 years, judgment was given in your favor. What will be the value of the money? So ADR actually saves time because parties are involved. They can make compromises. They can resolve their dispute as quick as possible. So you see. So that is the aspect we are looking at. The nature, it saves time, and then you see it's less expensive compared to litigation. When you go to court, you are paying the lawyer, you are paying professional fees, you go, you don't know the eventuality, something that may happen that you may need to appeal against a ruling, and then you need to bring more money, you need to go and serve, anytime the matter comes in and the other party is not in court, you need to serve him hearing notice, the expenses involved. But in ADR, you can actually negotiate your fee with the ADR practitioner. Now, you look at flexibility. Parties can say, oh, let's meet in a hotel. Let's meet in my house. Let us meet in this neutral place. Unlike litigation, you have to go to the courtroom. Even though you don't want other people to see you, you have to be there. You have to go to the courtroom. And then you see that is the problem. So flexibility, and then you can see that it actually decongest the courts. When matters are resolved fast as possible, the line of cases you see in court, sometimes you see 15, 16, 30 cases in a court list for a day, and one judge will be the one to sit over it. The next day, he has another matter. The next day, he has every day he's having matters, and the cost lists are up to 10, 15. Who is going to be writing the rulings? Who is going to be writing the judgments? And it's just one person. And most of the people, the judges who do the work are judges of the lower cadre, magistrate court, district courts. And most of them don't have assistance. They don't have legal assistance. They don't have a car. They don't have a house. So you see, it's actually a burden, a problem. So you can see that when matters are resolved as quick as possible, it actually reduces the burden. People will actually develop faith in the process. Say, oh, matters can be resolved as quick as possible now. You have had several people say, let's just forget about it. Or when you go, you are going to waste so much time. Now, it is important for you to know that this ADR we're talking about is open to everyone. Lawyers, non-lawyers alike, law students, non-law students alike. Everybody, is there. But you see, if you are a lawyer or you are a lawyer in training, you have a double advantage. Double advantage in the sense that you have lawyers are actually the gatekeepers when it comes to dispute resolution. So when there is a dispute or there is a problem, people first look for lawyers. Oh, I have this problem, I have this problem. And if that happens, you see that you can direct them to say, oh, explore ADR. In fact, is your professional responsibility. As you may see here, under Section 15 sub 3D of the Rules of Professional Conduct for legal practitioners in Nigeria, it actually provides that it is the professional responsibility of a lawyer to advise his client, to explore all the options available in ADR before resorting to any form of litigation. It is the law. So you see that you have that advantage, you have that opportunity to be able to help people resolve their disputes, within the shortest time possible. Are we together?
Yes, sir. We are together.
So how many minutes do I have before the next speaker? Pardon?
Hello, sir. Can you hear me clearly?
Yes.
You have about 15 minutes, sir.
Okay, 15 minutes.
Yes, sir.
Okay, let me, having explained the nature of ADR, let me use this opportunity to call on the Mr. Samuel to discuss, to make input in this regard. Then before we continue, and then before our next speaker join us, Mr. Samuel, or the moderator, what do you think? That would be fine, right?
Yes, sir. Thank you very much, sir. While we await Mr. Odoh Ben, we would have Mr. Samuel to take his session.
Okay.
Thank you so much. I hope you can hear me, please.
Yes, we can. Sorry, Mr. Samuel, before you continue, let me give a highlight of Mr. Nanchang's lecture this morning.
Very well.
Thank you very much. Thank you so much, Mr. Nanchang. It was such an impactful session. And from the session you just had with us, we know that ADR, which is popularly known as alternative. Okay, that was an interruption. I implore everyone to mute his mic until you're given an opportunity to speak. Thank you. So as I was saying, from Mr. Nanchang's lecture, a well-delivered lecture, we now know that alternative dispute resolution, ADR, popularly known as alternative dispute resolution, is also known as appropriate dispute resolution, negotiated settlement. And one take home for me this morning is that is from what Mr. Nanchang said, that conflicts exist. Conflict and disputes exist everywhere, and that conflict and disputes must be resolved. And it is in this resolution of disputes that opportunities exist. That is where disputes exist, where problems exist, then there are opportunities. You get opportunities from the dispute, from the existence of disputes, and also from the nature and relevance of ADR. We gleaned that from the lecture that, as in contrast with litigation, alternative dispute resolution is party driven, and other advantages that we have learned this morning. And also we have learned this morning that there is a new law that has been passed, which is arbitration and mediation, governing the ADR resolution mechanism. Thank you very much for such an impactful lecture once again, Mr. Nanchang.
Thank you.
Okay, now we would yield the mic to Mr. Samuel to have a session with us this morning.
Hi. Good morning, everyone. I hope you can hear me clearly.
Very well, sir.
Good morning, sir. I can hear you.
I must begin by appreciating my beloved brother, highly esteemed Mr. Nanchang, for that insightful presentation. It was awesome. I want to appreciate the ADR Society, Zaria, for this awesome privilege. And I want to appreciate them for their choice of topic. I think it is what is in vogue now and what we need to know. I overheard at the introductory part that they are beginning a new journey into ADR as an institution. I want to say congratulations to the current pioneers, and I do hope that what you're starting will grow and become mighty as the years go by. Beginning from where my highly esteemed professional colleagues stopped, Mr. Nanchang, speaking about the emergence, nature, and relevance of ADR, permit me to look at the topic methods and mechanisms of ADR. Like he said, ADR has different definitions to different persons. Some persons call it the African dispute resolution. Others call it affordable dispute resolution. Some persons go ahead and call it appropriate dispute resolution. But over the years, we generally know it to be an alternative dispute resolution. But permit me to stand with Mr. Nanchang in saying that ADR is not just an alternative means of resolving dispute, but an appropriate means of resolving dispute. Because over the years, we discovered that even litigation is part of ADR. It simply means when a dispute occurs, professionals look at it, which means, which channel, under which mechanism will we efficiently achieve resolution of this dispute. It's taking us through the emergence of ADR, it's taking us through some basics. And permit me to say at this juncture that as far as ADR is concerned, it is all about bringing amicable resolution, giving parties a say, putting the baton in their hands, recognizing who they are, because ADR is party driven. We all know that conflicts are inevitable. Conflicts cannot be done away with. But conflict in itself, they are not as bad as what people think. Because when there's no conflict, most times there will be no consolidation. So what people see in conflict as being bad, what people see in conflict as being retrogressive, means be seen by somebody else from a different perspective. One of the uniqueness of ADR is that it gives voices to people's perspective. There's this adage in ADR, nobody is actually wrong. Everybody owes it his own duty to express himself based on his own perception. Your perception is right. What causes dispute? Dispute is what happens when individuals decide to hold on to their opinion, decide to hold on to their perception, claiming it as being superior to that of somebody else. That is a summary of dispute. It is their right. We all have fundamental human rights, but we know that in exercising our rights, there should be caution. Caution in the sense that your right ends where the right of somebody else begins. So in exercising your rights, you must be cautious not to allow your rights to become a discomfort to somebody else. There's a simple illustration we use. If I write 6 and I'm standing at this side of the table, what will I be seeing? 6. But if somebody else is at the other side of the table, what do you think that person will be seeing? Will he be seeing 6 or something else? Please, I need your response. What do you think the other person will be seeing? Can you hear me?
9.
Beautiful. The other person is seeing 9. Now, the other person that sees 9, is he correct?
Yes, he is.
Okay. My own, what am I seeing? I'm seeing 6. Am I correct?
Yes, sir.
But if we decide to hold on to our individual rights, I'm correct in my assessment. He's correct in his assessment. If we hold on to our individual rights, claiming our rights, do you think there will be peace at the end of the day?
There will be chaos, sir.
There will be chaos. Thank you so much.
No.
Thank you so much. Your responses are quite priceless. And that is the summary of dispute. So what actually escalates issues is not the fact that there's a disagreement, but the fact on what means do we do? If we see differently, what means do we do? Is either I go over to his side or he comes over to my side. And that is the summary of the beauty of ADR. ADR enables parties to switch perspective, to see from the other person's corner, to see from the other person's point of view, and take a common decision according to what Mr. Nanchang said. Decide on what needs do we do. But you will agree with me that it is not as easy as we're saying it, because when tensions are mounting, there's a breakdown in communication. Each party begins to see each other as the problem, not knowing that they are not the problem, but the issue on ground is actually the problem. This is where ADR practitioner comes in. Individuals that have been trained, individuals that have been able to acquire skills that will enable them act as third-party neutral in bringing these disputing parties together with an aim of forming a forge, with an aim of clearing the path forward. Most times, what parties actually need is just a change in thinking. Most times, what parties actually need is just to be patient. And ADR practitioners are people that have been skilled. They are emotionally intelligent enough to know what actually is the issue. Where did it start from? And where are we now? Where next do we go? These and other activities are the tasks given to the ADR practitioner. But he or she carries this task under the specific door, under the specific mechanism that the parties have decided to choose. When we talk about mechanisms, mechanisms talks about the machinery of working parts, the different components, different perspectives the different subsets in a Venn diagram, the different channels, the different doors that exist under the ADR spectrum. But the mechanisms part of it, how do we fuse all these doors together? I know many of us must have come across the different spectrum under ADR, but the beauty of it all is that most of these doors, most of these platforms, they work hand in hand. It is possible, like in your home, there's a main door through which you access your apartment. And within the apartment, there are other doors. A door can take you from the dining to the kitchen. A door can take you from the kitchen to another part of the room, maybe your store. That is the beauty of it all. I know when our next speaker comes in, he will be able to throw more light on it. But the different spectrums within the ADR family, they work hand in hand. It is possible to navigate from one to the other. At this juncture, please permit me to ask. I know we have intelligent minds listening to us this beautiful morning. Let me hear from you. What are the spectrums? What are the mechanisms? What are the components of ADR that you may have had? Can you begin to name them? Let's see how we can pick them one after the other. The floor is open. What are the different strategies, mechanisms of ADR? Let me begin to hear your thoughts, please. You can unmute and share your thoughts, please. Can you hear me?
Yes, we can hear you clearly, sir. I think negotiation is part of the mechanisms.
Okay. Negotiation, awesome, beautiful. Does anyone have something else to say? Okay, there's a message from Queen Esther Choma and Franklin Chinson. They're saying arbitration, negotiation, mediation, conciliation. I see something like MCIArb, early neutral evaluation. Awesome, 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 beautiful. These and many more form of the ADR family that we'll be looking at today. Thank you so much for your response. Your thoughts are phenomenal. If we want to make attempts to pick them one after the other, going by what we were told by Mr. Nanchang, there is no law within the sovereign state called Nigeria that prohibits the practice of ADR. There's no legislation anywhere that kicks against ADR. Nowadays, in court rules, lawyers are required to explore ADR mechanisms in the settlement of disputes before resorting to litigation. Order 2, Rule 2E of the Federal Capital Territory High Court Civil Procedure Rules 2019 require the pre-action counseling certificates as one of the documents to accompany the writ of summons. This is a document that shows that the legal practitioner has taken the client through the process of counseling, making him more aware of the option of ADR. Having satisfied this, then they can proceed. So as it stands today, litigation is part of ADR because there are some matters that are best suited for litigation. You know, some persons have the mindset that ADR has come to replace litigation. ADR has come to kick out litigation. No, ADR has not kicked out litigation. I'm sure if not today, maybe at other times, you begin to appreciate the beauty of the synergy between the courts and the ADR practice. Because they go hand in hand. There are instances whereby a particular matter needs to migrate from ADR, from mediation, from arbitration back to the courts. comes back and processes involved. Looking at the multi-law courthouse practice, you understand better. So as it were, we are on the right track. We talked about negotiation, one as a mechanism in ADR. Negotiation is what we are all involved with on a daily basis, in an informal scale or in a formal scale. What is negotiation? It is a crisis resolution practice involving two or more persons, whereby they engage in discussion, and the discussion is with an attempt to resolve disputes, to resolve a crisis. It can be formal or informal. Informal are the ones that we are engaged with on a daily basis, but formal form of negotiation is the one that engages a formal person, a certified negotiator, or an ADR institute, whereby this certified negotiator is invited. And what is his or her duty to see how they can broker a breach in communication between parties, encourage parties to reach an agreement. Now, the beauty of all this is simple. When there's communication, a problem is half solved. But beyond communication, are they having effective communication or defective communication? Because in crisis, in this, there may be communication, but the communication will be defective. The communication, instead of improving the issue, it may be escalating it on the other hand. So the practitioner comes in, weighs all options, and looks for the best way to come in. That is negotiation, discussion between more parties. Okay, what do we do? It may involve compromise, this, that, and at the end of the day, parties are made to come to an agreement, a collective decision on what needs to be, either as a way of ameliorating what has been done or as a way of looking forward to peaceful coexistence. Although we may not actually achieve 100% restoration of peace, but the function of the ADR process is to put a stop to the escalation of the crisis. I'm sure there will be other platforms to go deep down in each of these. Then we come to litigation. As we all know, litigation involves the intervention of a third-party mutual. And the duty of the third-party mutual is to facilitate discussion, profitable discussion aimed at reaching a compromise. Like Mr. Nanchang said, when you go to the traditional court system, the pronouncement of the judge is final. You may decide to listen to the position of the parties, or you may decide to come from a very technical angle and pass his judgment. At the end of the day, one side is happy, the other side will not be happy. But do you agree with me that even when judgment is passed in the courtroom, that judgment that seeks to bring an end to a dispute, that judgment may further create other disputes? Do you agree with me?
Yes, sir.
Most likely, sir.
Most likely. Thank you so much for your response. Because at the end of the day, one side is happy, the other side is not happy. Even the side that is happy, you see what happens in our country. The side that lost out, they will say, no, let me go on an appeal. And at the end of the day, what is happening is either the judgment is upturned or it's taken to the higher level. Resources are being expended. Time value is not being put into constitution. And in most cases, we have seen cases that have lasted a generation and even gone beyond generation. There are matters today in court that the parties that are representing the interest now, are grandchildren of those that started it. I have seen cases where people need to travel into the country just to attend the court sessions. Now, what are we saying? I have seen this with due respect to the legal luminaries in the house. I have seen situations whereby parties are in court and their session is over. And they will come outside and ask the lawyer, please, what did the judge say? Where are we now? What next are we to do? Yeah, they're not in court, they were in court. When they don't hear what was said, yes, but they don't even know where they are. They don't even understand the scenario. At the end of the day, they are at the mercy of the council representing them. But in mediation, mediation empowers party. That is, Nanchang said, it is party driven. It empowers party and put them in a position to decide their fate, decide what they want, decide how they want it, decide when they want it. Parties involved in the conflict, it may be a communal conflict, it may be a family dispute, it may be a dispute that emanated out of contractual disagreement. Whatever the case is, mediation involves a third party neutral coming in on board, who does not act as a judge, who does not impose his way, but makes possible suggestions, encourage parties to understand what the actual matter is. Because in practice, there's what we call position, need, and interest. In some cases, what the parties are actually looking for is not what they need. In other cases, what they think they need will not actually serve their interest at that point in time. Let me go over that again. In most cases, what the parties, what they think is the problem is not actually the problem. In mediation, we have this principle. The principle is this: separate the problem from the parties. One party on this hand sees the other person as the problem. The more they begin to see themselves as the problem, the more the crisis is being nourished to escalate, and at the end it will consume all of them. So the mediator has the skill to actually separate the parties from the problem. So I can facilitate discussion. So I can facilitate sessions with the aim at reaching a settlement agreement. And how is this being done? There are different stages involved. There's the preparation stage. This is the stage whereby matters have been filed, claims have been filed. There are different ways matters can be referred to mediation, either by direct intervention of the mediation institute, either by walk-in. Parties in dispute or a party in dispute may approach a mediator or may approach an ADR center. I'm happy we have SHATI here that is licensed to carry out ADR services. They may decide, I am an agreed party, I may decide to approach SHATI and lay down my claims. Looking at all I've said, they may decide, I think mediation will be best for this. Or in the process of drafting the contractual agreement between parties in the contract, if they have been stated, there may be an ADR clause that states that if any dispute arises at whatever point, mediation should be adopted. If that is the case, then it is obvious that that is the path the parties will take. There's the preparation stage, whereby the individuals are appointed, filings are made. There's what we call pre-session, whereby parties come together and they decide on terms, the fees, signing of documents, and there are so many documents that are crucial in the process of mediation, but two stand out: the mediation agreement form and the confidentiality form. I remember clearly Mr. Nanchang stating emphatically that one of the beauty of ADR that it is confidential and classified. Everyone, whether sane or insane, whether rational or not, has the liberty to walk into a court on any day and sit down and listen to proceedings. Anyone can apply to any registry for documents, whatever document that in the court of law is a public document, but that is not the case when we are speaking about ADR. Parties that are not involved in a dispute are not allowed to be part of the process. So there's the preparation stage, there's the opening stage, there's the setting of agenda stage. There are so many stages involved in mediation. And at some point, when the mediation agreement form talks about is a commitment to the parties that yes, we are willing to submit to mediation. It must be clearly stated. And there's another from the confidentiality form. Whatever happens within the process of mediation is not to be released outside. Whatever is being said cannot be used against any party in the mediation process. And the mediator cannot be called upon to testify for any reason except where it borders in criminality and the state of the nations like this. Those are extreme cases. Otherwise, it is highly confidential. And one of the beauty about mediation is there's a concept called caucus. I hope we are still together. Please confirm with your response.
Yes, sir.
Thank you so much. I appreciate it. During the process of mediation, the mediator may decide to caucus. Caucus means instead of having both parties, we can decide to discuss with one party. And there and then, he or she will be able to open up to you if they so choose. One of the things that we say about ADR, when you are before a judge in the court, they will always ask, guilty or not guilty. Now, no matter who is there, no matter what has been done, even if he or she carried out that act, what is the default response when someone is asked guilty or not guilty? What is the default response in court?
Not guilty.
Thank you so much. Not guilty. That is
Not guilty.
Yes, not guilty. That is the default response. But in ADR, in mediation, a party has the privilege to say to the mediator, I am guilty. In ADR, our choice of words are refined and they are packaged in such a way to give the parties, no matter what they've done, no matter on which side they belong to give the parties a sense of belonging. In a proper mediation, arbitration, and certification training, I'm sure SHATI will come up with one shortly. You'll be told the qualities of the mediator, what mediation entails is a beautiful exercise, a beautiful experience. During caucusing, parties can open up to the mediator. I did this, I did this. This is why this was done. That is why that was done. And at the end, they can tell the mediator, please, I don't want this information to get to the other party. It happens in mediation. ADR is so beautiful, and I'm proud to be an ADR practitioner. There's the bargaining stage. From the information the mediator has obtained from the different parties, he or she is better positioned to know what needs to do. And this is one of the things we say in mediation. Parties have what connects them, and parties also have what divides them. When you want to be technical, you are tempted to lay emphasis on what divides. But an experienced ADR practitioner, we lay emphasis on what unites, down on what divides. If it's a contractual agreement and the claimant is asking for 2 million naira, And the respondent said, no, I'm going to offer you 1 million now. The question is this: one side is holding to 2 million, the other side is holding to 2 million. What is connecting them is 1 million. So a technical way of handling the issues is, oh, you said you want 2 million. How low can you come? Oh, you can only offer 1 million. What else can you add to what you have been offering? So we don't escalate the issues, we de-escalate it. Between couples, if there's a child in question and the couples have issues, they want to go their separate ways, fine, no problem. But when there's a child in question, it is obvious that there's something connecting them already. You can explore what connects parties to guide them, help them to navigate to safe landing. Instead of drowning in the sea of conflict, you can assist them to the shore. At the end of the mediation process, someone once, there was a court referred matter, it was referred for mediation, and the party came in and said, we just came to show our face. We are not going to abide by this process. I smiled. By default, he was expecting when he says that, I'm going to say, no. I smiled at him. And I said, thank you, sir, for expressing your thoughts to me. It has further enabled me to know how best to handle this matter. If you have not expressed your thought, I would have been at a loss on what needs to be. He was looking at me. I was still smiling, and I told him, it is a court-referred matter, and I'm glad you are here. The only way out of this process are 2 documents. Document 1, settlement agreement. Document 2, inability to resolve. So all you need to do is just to choose, but you must go through the process to enable you to have these 2 documents. And at the end of the day, he went through the process. He was never the one championing the cause of settlement. There are so many issues, there are so many concepts in mediation. Somebody else talked about arbitration. I hope I've been able to throw light into negotiation and mediation before moving to the next. Are we good?
So questions
Yes,
will be
sir.
said
Okay.
after the session.
So how much time do you have left? So I know how to wrap up.
Okay, thank you very much, sir. You have until 11:30.
Oh, that's 7 minutes. Thank you so much. I appreciate this feedback. Oh, we have arbitration. Arbitration. In mediation, you have the mediator. In arbitration, you have the arbitrator. Arbitration is a method of dispute resolution where parties appoint a mediator. It can be institutionalized arbitration, or it can be individual arbitration. Parties may decide to approach an arbitrator on a personal basis, or parties may decide to approach an institute. And I'm glad that we have a reputable institute in Nigeria, the Nigerian Institute of Chartered Arbitrators. It is their duty to regulate the practice of arbitration in Nigeria. There are so many processes involved in arbitration. Like we said earlier, it is in most cases we always encourage parties at the point of entering into any form of contract, into any business venture. It is good we include our ADR clause in drafting the agreement. But most cases, some business are executed without any form of agreement based on oral trust. And along the line, we always discover that there are issues that come up. So in arbitration, there are so many processes involved initiating the arbitration. It happens when there's an issue. The problem must occur before we activate the arbitration clause. Initiating the arbitration process, talk about the appointment of arbitrators, the panel of arbitrators, they constitute themselves preliminary hearing, submitting all the claims. And arbitration can be based on oral evidences, oral submissions, or documented submissions based on the agreement between the parties. Parties can just decide, okay, the panel can say, let us just submit all your documents. I will go through them and make our decision. And decision of an arbitrator comes in the form of an award. Mediation comes in the form of settlement agreement. Arbitration comes in the form of award. Arbitration is much more technical in quotes than mediation. Mediation is much more flexible than arbitration. It depends on the content, what is contained in the ADR clause in the contract of parties. There are instances whereby a particular matter may move from mediation to arbitration. And along the line, the award of any arbitration process is usually published. And there's a time frame under which matters are supposed to be resolved under arbitration. I have 4 minutes more. Talking about conciliation, I wouldn't know if I should go into conciliation because before now, like what Mr. Nachang said, we had the Arbitration and Conciliation Act. But towards the last minute of the last administration, the former President Buhari signed into law the Arbitration and Mediation Act. So I wouldn't know if I should still talk about conciliation. But however, conciliation involves a situation where a third party comes into the situation, is at liberty to make suggestions on how parties can resolve that dispute. Permit me to use the remaining 3 minutes to talk about ADR has gone green. You know, the whole world is going green. ADR is going green. Look at the beauty of today's webinar. We are all in the same space, but we are not in the same location. There's a virtual environment that has given us the ability to connect together, to rub our minds together. This is great. Arbitration is no longer what we do physically. We can do it technologically. Processes can be served online. There's what they call ODR, online dispute resolution. Is an emerging phase of ADR. Online dispute resolution is an emerging phase of alternative dispute resolution, whereby disputes can be resolved online. There are instances whereby a matter begins and ends without the parties coming together physically. But seamlessly, it can be pioneered. The concept of ODR through whatever means that is suitable for the parties. I believe that there will be specialized trainings organized by SHATI to handle all the specialized areas. I want to appreciate you for coming on board today, and I do hope when next SHATI makes a clarion call, you will make yourself available and come on board in order for us to sharpen our knowledge. I want to appreciate every one of you. For this time, I want to especially appreciate Mr. Nachang for this great opportunity to partner with you in today's activity. Kudos to ADR Society. Wishing you much more glorious adventures ahead. Thank you. I appreciate you.
Thank you very much, Mr. Samuel. You have done great justice to the topic of the day. And thank you very much, Mr. Nachang. Please, do you have anything to add to what Mr. Samuel has said before we continue on this session? Hello, please, can everyone hear Mr. Nachang? Okay, I guess his mic is muted.
Yes, his mic is muted. Mr. Nachang, please, you can unmute. Mr. Nachang? Or Mr. Nachang?
Okay, thank you very much, Mr. Samuel. While we await Mr. Nachang's response, I have quick highlights from your session. It has been an impactful and insightful session. From the session, we have gleaned that ADR enables parties to switch perspectives and have a common ground. Then one of the take-homes for me is that is that in mediation, there's a principle that you should separate the parties from the problem, that you should concentrate on what connects the parties so that you can achieve resolution of the dispute. Then another thing is that in ADR, I can hear my voice echoing. Please, is there anyone whose mic is not muted? Okay, thank you very much. So also from the session, we have gleaned that mediation come in form of settlement, while arbitration come in form of award, and many other things that we have gleaned from today's session. Thank you very much, Mr. Samuel. Now we'll take questions from the audience and feedback. Please, if you have a question, you can raise your hand and you'll be given an opportunity to ask your question. Queen Esther, you can unmute your mic and go on with your question. Thank you.
All right, thank you so much, ma'am. Thank you so much, sir. It was such an insightful section. Please, am I audible enough?
Yes, we can hear you.
Yes, you are.
Yeah.
All right, thank you. So my question is, how do we differentiate between mediation and conciliation? Because the two deals with the third party, as I have written on my notes.
So, thank you so much for your question. As a mediator, you are not to suggest settlement terms to parties. Although in the new act that has just been signed into law, there's a section that says that in mediation, mediators can suggest settlement terms to parties, just to suggest. But as it were, when we are comparing mediation and conciliation, how it has been, in mediation, you assist parties to reach a settlement agreement. You guide them, asking critical questions, helping them to see from different perspectives. But in conciliation, a conciliator can assist parties in consolidating the dispute by suggesting terms of settlement. But as it is now, we no longer have conciliation as part of the act. What we have is arbitration and mediation act. So that part of having ability to suggest, it has been subsumed into the role of a mediator. Please, if you don't have the floor, if you don't mind, please mute your mic. So I've given you two scenarios, how it was then and how it is now. When we still have mediation and conciliation, a conciliator can go a step further apart from assisting parties, take the vote by the horn and make suggestions. I think if you do this, I think if you do that. But in mediation, the mediator only assists. Don't forget that when parties come, it's like going before a counselor. Professionally, counseling is defined as a system in which a counselor engages a counselee and assists the counselee makes an informed decision. Professionally, a counselor will not advise a counselee, but the counselor will explain, expose, expand the issues, and give the counselee more information about its decisions. If you do this, this will be the outcome. If you do that, that will be the outcome. Having those basic information, the counselor is not being able to make an informed decision based on appropriate information. When parties come before mediation, before mediators, before ADR experts, like practice have shown, they think we have the solution. When parties come, they are trying to convince the mediator, trying to convince the arbitrator, not knowing that it is a party-driven process. Instead of mediation advocacy, we are being taught the mediator is not the focus. The focus is the person on the other side. So a mediation advocate is key to see how they can broker communication between both parties. Finally, to summarize my answer, as it has been before, a conciliator can go ahead beyond assisting parties to suggest possible terms of settlement, but a mediator is not at liberty to suggest. A mediator can only assist. But as it is now with the new law that has been signed, that part has been subsumed into the role of a mediator. As it stands now, there's no law governing conciliation, but we have Arbitration and Mediation Act, and in that act, the mediator can at some point suggest, not impose. I hope I've been able to clear it out. Thank you. Any other question?
Thank you very much, sir.
Thank you very much, sir. I think Queen Esther is satisfied with the answer, and we have all learned from the answer you've just given to Esther. I think another person, yes, Ayomide, you can unmute your mic and ask your question. And please, you can direct it to any of our speakers. Mr. Nanchang too is on board now.
All right, no problem. Thank you. I'd like to say thank you to the speakers. It was really an insightful session. But I have two questions actually. And then my first question is, what makes the decision of an arbitrator or a mediator binding? Like, are there certifications that you must have before your decisions will be binding? For instance, a judge, we know that the decision of a judge is binding because he has gone through the process of, going to school and then 10 years practice and all of that. So what makes the decision of an arbitrator binding? What are the certifications you need to have before your decisions can be binding? And then my second question is, with regards to litigation, with criminal matters rather, are there matters that an ADR practitioner is exempted from? For instance, in matters like rape or, abuse, family matters and abuse, where the husband may probably abuse the wife, and all of those things like domestic violence, there are certain acts that the law has provided certain punishments for. So are there certain matters with regards to criminal litigation that ADR practitioners are exempted from? I hope my question was, yes, so that's my question. I hope we got the question though.
Yeah, we got your question, but you need to direct it to who has it. Okay, it's not your back. Thank you. Welcome, sir. Maybe you want to take the first shot.
Well, I think you can answer the question.
Okay,
you can answer the question. I want to, after what I will share one or two things on before.
Okay. Thank you so much, sir. I am deeply grateful, sir. I think the first question you asked, you wanted to know what makes the decision of an ADR practitioner binding? Permit me to draw the line by throwing more light into what I and Mr. Nanchang have been saying. There's a big difference between litigation and mediation, arbitration, or any other ADR mechanism. What is the outcome of litigation is judgment. And that judgment is a product of the perception, the conviction, and understanding of the judge or magistrate or president, as the case may be, depending on the cadre. But in ADR, if you are talking about mediation, the outcome of mediation, if it is successful, is called settlement agreement. And a settlement agreement is not a reflection of the decision of the mediator. The settlement agreement is a reflection of the decision of the parties. At one point, I was seeing 6, he was seeing 9. But now I decided the mediator took me to his side. I cannot see what he's saying. Now that we have a common understanding, what do we do in going forward as far as the dispute is concerned? Okay, I think I need this. This other person says, okay, I think I need this. All what the mediator does with the aid of a DR or whatever, depends on the system under which that mediation exercise was carried out. They come up with a document capturing the decisions of the parties. But you know, the parties may have an intention. The duty of the mediator is to help them put it in an appropriate sequence. Just we have been told, if you want to write an agreement, you know what you want to do, but seek the aid of legal practitioners because there's a way they will couch it. So mediation product is the decision of the parties, not the decision of the mediator. If there's this adage that said, if one person cooks for your house, the food will not be sweet. But if everybody is involved in cooking, there's no way the food will not be sweet. Because if everybody cooked and at the end you're not satisfied, who will you blame? Because everyone was part of the process. So the settlement agreement is a document that captures the decision of the parties and not a reflection of the mindset of the mediator. Secondly, if you want to look at arbitration, arbitration is an award, yes. The award captures the decision of the arbitrator. When we are being told that when the process is flawless, when all the laws are followed, when all the stages are handled one after the other, it will be difficult for one party to renege at the end because they will all sign to the document. But if an award, talking about arbitration, if an award at the end of the day does not favor one party and a party decides, no, I want to go to court, no. The question before the judge will be, did the arbitrator follow the necessary law? Were they involved? If yes, they were involved, that agreement is binding. I don't know if I've been able to explain that first part. Then the second part talks about, are there limitations to the kind of disputes that ADR will handle? The answer is a yes and a no. Obviously, we know that criminal matters are not suitable for litigation. But within recent times, we talked about rape. There's what they call restorative justice. The concept of restorative justice have sort of crept in. And practitioners, some of them are still on the divide. What goes, what does not go. There are some matters that can be handled under the platform of restorative justice. And restorative justice comes to bear where the offender is given an opportunity to interface with the other party And you come to the realization, yes, I know what I have done is wrong. Most of the people that go to court, they don't just go to court because they're looking for the money. They go to court because they want to exercise their right. They want you to feel the grief of what they've gone through. Imagine a matter that lasted over 4 years in court. At the end, the party said, I just wanted you to say sorry. Because you were so stubborn, that is why we lasted this long in court. So yes, there are criminal matters that are outside the confines of ADR, but there are some matters that are within the confines of restorative justice. Thank you so much for your time.
All right. So thank you very much. Briefly, in addition to what my brother has said, I just want to run through some of the skills that you need to develop as an ADR person. First, you know, when you take up trainings, you know, some of this training, okay, when you take up some of these trainings, depending on your area of interest, you are going to develop one, you see, skills like communication skills, which is very, very vital and important. And you need to look at, you develop conflict resolution skills, you acquire them, and then you know how to show empathy. And more importantly, you look at emotional intelligence as a vital tool in helping parties to resolve their disputes, and even if you are acting as an arbitrator. Then you look at how do you analyze disputes. You know, dispute analysis is one of the major tools you also need to know. And how do you get this? You will look at what you need, some of the things that you need as an ADR enthusiast or to become an ADR practitioner. What do you need to do to develop yourself? First, you need to take up trainings. Somebody is asking about certification. What do you need? First, you take up training with institutes. You know, like some of us, you can see that we are not just limited to one institution, but you need to start from somewhere. Take up relevant skills training, like Settlement House is having a training that is coming up, a certification training in mediation that is coming up between 26th to 30th of this month. 5 days intensive virtual training in mediation. You can decide to take up that training, and then you will learn some of these skills in proper perspective, you know. So you attend trainings, you know, there are some trainings like this, free trainings like this also. You can attend seminars, you know, and all of those things. Attend trainings, very, very important, especially in the area where you want to specialize. Is it mediation? Is it arbitration? You know, you need to take up trainings in different aspects where you develop the necessary skills. And then, you know, this is just peripheral. You have opportunity to do practical simulations that will help you, you know, put into practice what you have learned during the training, you know. So you will talk about that. Then you need to find your area of specialization. Maybe you are someone who is interested in property law, or maybe you are interested in IT, you're interested in different aspects. Develop specialty and then bring in dispute resolution, ADR into it. Once you are specialized, you see that when people are looking for someone who is going to help them resolve property-related dispute, especially out of court, you have the subject matter expertise. Then you must also look for opportunity for mentorship. You look out for people who have advanced in the area where you want to specialize, and seek for opportunity to have them mentor you. You know, we've mentioned taking up relevant courses and training in ADR. You know, we have seminars, you have webinars, you have, you know, certification trainings, you know, family law, you know, family mediation, you want to do community mediation, you want to do different aspect negotiations, you know, emotional intelligence, all those things you can take. Then join ADR organizations or groups or associations like the ADR Society, you know, that you have in school. Join those organizations. This training is coming to you free because, you know, of your association with the ADR Society. If not, you would have been charged. So if you join organizations like that, volunteer your skills. Volunteer your skills. When you have ability to be able to draft, to read, to do certain things, you know, volunteer those skills in these ADR organizations, and it is going to help you develop abilities. You are going to be exposed or given opportunity to do certain things that ordinarily you will never have the opportunity to do so, you know, because you are volunteering, you know. So, and then you can make research, you can make writings, you can write on the area of your interest. You know, you want to go into let's say media law, you know, you write articles, make publications, write essays in that area, publish it. Your WhatsApp status, your Facebook, your social media, post these things in your area of practice, you know, before time you see that you are developing the expertise that you need. Then you need to advocate for ADR. You know, when you see people who have disputes, who have issues, who have problems, you advocate. Please, you can resolve these people, you can advise, you can resolve your problem through ADR. You can explore these means, especially now that our brother, Mr. Samuel has explained to us some of the mechanisms that you can explore in resolving your disputes. You can say your disputes can be resolved through mediation. Negotiation is best suited. Oh, arbitration is better. Oh, when you are drafting your agreements, please include dispute resolution clauses so that you avoid situations where you go to begin to battle in litigation and all of those things. So these are things that you need to advocate. Trainings like this, like the one coming up, Settlement House, advise students to join and do this training. In fact, it is given to students at a discounted rate. By the time you get acquainted and get your certification from school, and then by the time you graduate, you see that you are no longer a novice. And before you graduate, you must have established yourself on certain basic things that you need to set up your practice and begin. One thing you should know about ADR is that even as a student, you can practice. You don't need any certification, you must be certified, you know, and all of those things. No. But the reasons why you engage in formal training and certification is that your skills will be enhanced, and then you have an identity. You have a professional organization where you are related to. In case of anything, you have people you can reach out for help. You have people that can guide you, can mentor you. You know, that is the importance of some of these things. So if you want to be an arbitrator, you know, the Chartered Institute of Nigeria Institute of Chartered Arbitrators, you know, they are there, they train and certify people in arbitration. ICMC certify people in mediation. Settlement House actually does all of them. As you see the name, Settlement House ADR Training Institute. We train people in mediation, in negotiation, in arbitration, and all of those things. That is how it is. So you take up this training, and you see, you can train with ICMC and decide to train with SHATI and decide to train with MCIArb. All of these things will broaden your horizon, you know, and your competence in the area you want to practice. We have looked at ADR mechanisms already, and then these are some of the things that I feel you should take note. I hope I've touched on some of the questions that somebody was asking on the issue of certification. So thank you very much. If there are further questions, we're happy to attend to them, and then maybe bring to you formally some of the instructions or some of the things about the forthcoming training of a Settlement House where necessary. Please, the moderator.
Thank you very much, Mr. Nachang. That was an insightful one. And from this moment, we'll take only one question. One question, please. Any question from anyone? Okay, I take the silence for no question and well understood. So Mr. Nachang, please, you can unravel what you have for us before we come to the end of this session.
Okay. Thank you very much once again, Mr. Samuel, for being with us. We really appreciate you, sir. We thank you for creating time out of your busy schedule to be with us. I believe that the ADR Society of Ahmadu Bello University appreciates you and values you and hold you with in high esteem. We are very, very grateful, sir. Thank you. So without waste of time, one thing I consider very, very important is that I believe in giving students opportunity to actually add value to themselves. And that is why I will use this platform to bring to your notice officially the training that is coming up, settlement house training, mediation skills training, MST and certification that is coming up between 26th to 30th of June. It's actually a virtual training. We're doing that training together with the ADR Society in collaboration with the ADR Society of UNN, University of Nigeria. And then we want to see how some of you also, especially for the fact that it is a new society that was just birthed. We want some of you to take advantage of the training. Now, for the purpose of the training, we have scheduled different fees for students, which is the sum of 75,000 naira. Your pioneer president, let me say, Mr. Joseph, has been doing a lot. He has been doing a lot. I remember that yesterday till around 10, 11, in the night, we are still discussing on how to go about some of these things. He has been doing a lot to ensure that he gets this association, the ADR Society, established, and then bring opportunities like this to you all. So the training fee for the students is actually 75,000 naira. And then he has discussed extensively on trying to see how some of you may pay for that training. And then if you don't have the money, you can make some instrumental payments, the details of which I believe is going to make it available. Then one also important thing for us, as an institute that we want to do for an organization like yours that is here in Kaduna with us, we want to give you an opportunity to partake in some of the sponsorship. We have a partial scholarship or sponsorship for some students. The conditions will be highlighted by the Mr. Joseph, your pioneer president. He will highlight some of the. We will require that participants should be able to pay the 50% of the fee, that's the 50% of the 75,000 naira. And then we expect that they are going to write an article, they will write an article on ADR, especially the new law, and then some other aspects that will be made available once they write, and then they formally write an application, to the institute and direct it appropriately from the information that will be passed across. Then persons who have been selected for to enjoy that opportunity or that scholarship will be contacted. Once your ACA meets up the requirement and you are selected, you will be contacted. For those who are unable to partake in the scholarship, you have the opportunity to pay the training fee. And then I will advise that you please try and take advantage of it, especially now that you are still students. The training fee for ADR trainings outside, of being a student is actually very huge. And I expect that some of you will take advantage of it. If there are further questions on this, we will answer them. And let me give the mic back to the moderator for maybe further comments. Thank you.
Thank you very much, Mr. Nanchang. Thank you for having our best interest at heart. Please, you heard him. It's an opportunity for everyone, and it's an opportunity really everyone should jump at. No knowledge is too expensive. And so would be the next on our agenda is the closing remark by the head of the caretaker committee. But before that, I would like to apologize on behalf of the ADR, on behalf of the ADR Society. We apologize for not having our second speaker present here. It is due to circumstances beyond our control. And you would agree with me that our speakers, the two speakers, have done justice to the topics for the webinar today. Thank you very much. Now I yield the mic back to Joseph.
Yeah, thank you so much, Joy. Thank you so much. Thank you so much. You have really done well with the moderation. Okay, let me thank the Settlement House for affording us this opportunity to collaborate with them to ensure the success of this webinar. And then let me thank our speakers individually, Mr. Nanchang, the Executive Director of Settlement House ADR Training Institute, and Mr. Samuel, a Dispute Resolution Officer at the Edo State Multi-Door Courthouse. Thank you so much. Thank you so much. Thank you, everyone, all participants here present that have stayed through in this webinar from the beginning up to this moment. I want to thank you all so much. For the mediation training Mr. Nanchang was talking about, all plans are already on ground, so we'll just put finishing touches to the framework. We reached an agreement with the Settlement House to provide us with kind of flexible payments. So we have special sponsorship where selected students will just have to pay 50% when they meet up with certain criteria. You just have to pay 50% of the course fee, and then we also have a payment by installment for other interested students. Now, for the certification for this webinar, if you have registered your interest, I'm referring to both students and non-students who indicated interest for the certificate of participation for this webinar. If you have indicated your interest, you would have your certificate sent to your email within the week. Yes, within the week, we'll send your certificate of participation to you. Yeah. So thank you all so much for making it to this webinar. Thank you so much. Thank you.
Thank you. It's nice being with you all. Thank you, Mr. Samuel, for being with us. We really appreciate the honor. We are glad, we are grateful. We look forward to better relationships, henceforth. Thank you.
Mr. Nachan, I must thank you for allowing me to share a space from the professional platform. Thank you so much. Thank you for ADR Zaria for having me. Thank you.
Thank you very much. So, have a nice day ahead of you.
Yes, I thank you.